guess we can get started. Some of you know who I am. I'm Joyce Moy, the Executive Director of the Asian American Asian Research Institute, also known as ARI. And I'm also a member of the Board of Directors of the U.S. Pan-Asian American Chamber of Commerce. And I have with me two colleagues, Mr. Rajiv Paul, who is a CPA, has his own firm, and he'll be giving us some information about the kinds of tax issues and other issues that he thinks are important for small businesses to be aware of. And then we have Larissa Barano, who is a State Farm agent, and she will be talking about the small business issues in the insurance arena, something that's extremely important for you to know about as well. I'm a former practicing attorney, and I'm going to talk to you about choosing the proper business form. Should you be a corporation? Should you be an LLC? What is an LLC? Why should I spend money and create any of those entities? Why don't I just be a business owner as a sole proprietor, and so on? So I want to touch on what the differences are among the different kinds of organizations, why you should consider those organizations, and what kind of organization would work best for you. Now, generally speaking, as an attorney, when we talk to clients about the kind of organization they should choose, we ask a number of questions, because for small business owners, the key is not always knowing the answer. The key is knowing what questions to ask. So I hope that you'll get that from today's conference. But one of the things I always ask clients is about their plans. What do they think is going to happen in the long run for their business? Is this the kind of business that will be going public? Do you see yourself winding up on the stock exchange? Or do you see yourself as a company that is likely to stay somewhat small, perhaps a local or regional business? And I ask about things like assets. Do you have a lot of personal assets? Where are you in your life? Because one of the major reasons for forming a corporation or a limited liability company, for example, is to protect your personal assets from business creditors. What that means essentially is that even if you have millions of dollars of personal assets, if your business fails, your creditors cannot touch your personal assets, providing, however, that you did not sign a personal guarantee. So I'm trying to be very clear about that. If you have signed a personal guarantee on a particular debt or a particular loan, then the form of business that you have will not protect you from those creditors reaching into your home, your bank accounts, and other things. So these are the kinds of things we need to know. Also, in my experience as a small business advisor, I ran a business development center where we worked with nearly 2,000 businesses. One of the things I always find is that people make decisions based on tax issues. I personally don't agree on that. What I think you should do is make your decisions based on your business needs and business reasons. And because you need to make that decision, you then want to consult experts like Rajiv to talk about how you can best maximize the benefits. If you have to buy a piece of equipment because it makes sense for your business, how can I maximize my tax benefits from that so it ultimately doesn't cost me as much as it would otherwise? So these are kinds of things to think about again. So let me just go quickly over a number of business organizations, and I am going to eliminate the limited liability partnership, because I think for the average small business, that's a form of business that doesn't apply. That's a kind of business that would apply more to professionals, such as doctors, CPAs, lawyers, and so forth. So I'm going to focus primarily on sole proprietorships, partnerships, corporations, and limited liability companies. Okay, so first, the sole proprietor. In the case of a sole proprietor, there really is nothing you need to do to start your business. You can just hang up a shingle and start your business. There are no formalities involved in terms of filings. The business is you, the sole proprietor. When you die, the business dies with you. Now, you know about the fact that families sometimes inherit the business. Let's say your daughter takes over your business after you die. Well, in that case, it would be considered a new sole proprietorship, because the first proprietorship in your name died with you. And again, there are no filings involved. This is what's known as a common law form of business. You can just hang up a sign, Joyce Moy's Dress Shop, and start business. Now, if you are going to do business in a name other than your own, what will happen is you will have to file what's known as a business certificate with the county clerk's office in the county in which your business is based. The reason for that is that sole proprietors are personally liable for all business debt, all business liabilities. So if you're doing business in a name other than your own, you need to file this form. So if somebody falls in my dress shop, they'll know who is responsible. So if I have a dress shop called Sunshine Dress Shop and somebody falls in my dress shop, they can look at the county clerk's office and find out that Joyce Moy is the sole proprietor and she is personally responsible for the business debt or for the accident that happened. Okay? So, and if you fail to file that certificate, in New York State, it is in fact a misdemeanor, so you have to keep track of that. It's relatively inexpensive to file. I have the filing fees in here. So a lot of people don't want to form sole proprietorships. Sole proprietorship income and expenses are reported on a Schedule C, which is on your personal income tax return. So again, you can see how clearly it is linked to the individual. A lot of people are worried about that personal liability, which is why they look at forming a different kind of business. And again, they will pay taxes on the income generated from that sole proprietorship on their personal return, and I'm sure Rajiv will mention that again and perhaps expand on that point. Partnerships. In the case of partnerships, from a legal perspective, it's when two or more parties get together with the intent to share management, profit, and losses. That's the way the law looks at it. And when I say entities, I mean not just 2 people or 3 people or 10 people, but I mean individuals. It could be 2 partnerships are partners. It could mean 2 corporations and an individual are partners. So that's what I mean by entities. In this particular case, the law treats all of the partners as having equal say in the management unless otherwise specified. So if you have a partnership agreement that says that John has 30% of the partnership, Mary has 60%, and Joe has 10%, then the management has to be clearly stated that the management votes are the same. The same thing with profits and losses. In the case of profits, unless it is specified in a partnership agreement or in some other sort of agreement among you, the assumption is that all of the profits are divided equally among the partners, and then losses are divided in the same way as the profits unless otherwise specified. So you're hearing these key terms like unless. The way that law always works is that there's a general rule and then there's always an exception. So this is something that you need to keep in mind. If you are forming a partnership, it's very important to consult an attorney about putting together a partnership agreement. Because you and your partner may get along very well, you may know a lot about one another, you may be able to make decisions in a very natural, free-flowing way. But you may forget 10 years from now exactly what it is you agreed at the time that you decide that you're going to end the partnership, for example. Let's say partner A decides that he wants to retire and go to Florida, and partner B wants to continue the business. Well, what happens then? How do we decide what B is going to buy A's share out for? Or what happens if A becomes disabled? What happens then? What if you have to bring somebody in to fill in his position while he's disabled? How do we account for that? These kinds of things are important. And because we're talking about money, it's more important to talk about this than it would be in a marriage. Partnership agreements, shareholders agreements, membership agreements, which is what applies in a limited liability company, is like a prenuptial agreement. You want to lay everything out up front. What happens if I want to sell my shares? What happens if I die? Perhaps the company wants to buy what's known as key man or key person insurance to pay off the family of the deceased partner so that the remaining partner takes over the entire business without having to deal with the family. So these are things to think about. It's important to have a partnership agreement, and that you really need to speak to an attorney about. In the case of partnerships, the individual partners are personally liable for the partnership debt. They are jointly and severally liable. What that means is that your business creditors can come after first the partnership assets, and if the partnership assets are not enough to satisfy the debt, they